we have with us Mr. Pratik Datta, who's just completed his MSc Law and Finance from Oxford. Before that, Mr. Datta was working as a research scholar with the National Institute for Public Finance and Policy, during which time he was instrumental in drafting many of the codes that will shape the Indian financial regulatory scenario for years to come. On a personal note, he's also an alumnus of NHS, where I come from. And it is good to see him again, and this time addressing our students.
Thank you. Thank you, Arjun. Thanks for turning up today. So I'll just, okay, so the presentation is about the IBC. I hope, have you guys heard about the IBC? Okay, cool. So how many of you are familiar with the basic idea of bankruptcy, like, you know, what's the process? I'm sure you must be reading in newspaper, like this is happening, that company is going in liquidation and stuff like that. How many of you have a basic idea of the committee of creditors? Like, what's the process, right? I mean, CIRP, like, if you're not, I mean, if you're unfamiliar, can you raise your hands? Because then I'll get a sense of how many of you are completely unfamiliar. Okay, so quite a few of you are unfamiliar. So I'll actually start from the basics. So that was the idea, because I guessed, like, I should start from the basics. So some basics, okay? So we all know what is a company, right? So yeah, company, legal entity and all that. So as law students, all of you are aware of it. But from the financial point of view, what matters are the investors of the company. So a company has various stakeholders, right? Employees, suppliers, customers, etc. But from a finance standpoint, the most important stakeholder that we will be talking about today are the investors of a company, right? So why are the investors investing in the company? Because they will get some returns out of the investment, right? So before the investor reaches, before the investment or the total returns goes to the investors, there's a tax component that goes out of the total returns, right? After the tax, what actually goes to the investors is known as free cash flows, okay? And as you know, there's a capital structure of the company, there's debt investors and equity investors. I'm assuming preference is debt, so that kind of simplifies the thing. So the debt investors will get coupons, the share investors will get dividends, and that depends on the capital structure. What we are interested in today's discussion is the free cash flow, right? So let's imagine a project, okay? Any random project, okay? So it will give you some free cash flows at regular intervals of time, okay? So, but for that, you need to make some initial investment, right? So how do you decide whether you should invest in this project or not? This is the basic of corporate finance, right? So the basic theory of corporate finance basically says that what you essentially need to calculate is, so you all know about the time value of money, right? You can move money across time, right? So you can move the FCFN or FCFI from sometime in the future back to the present, right? That's the present value. You add up all the present value of all the future projected cash flows, and you get the present value of the project, right? So if this present value is more than the initial investment, you invest in the project, right? So net present value of the project is greater than 0, right? You all understand that, great. So what happens in insolvency? So let's imagine there's a company that is doing only project X and nothing else, right? There's a corporate entity that is doing the project X, right? So let's imagine it has a debt of D. D is the amount, right? There are multiple debtors. And at time T0, it defaults to one of the creditors, right? Now, the next question that we are interested in is, should this company be liquidated or should it be continued, right? How would you calculate that? Now, there are two possibilities. One, this is called financial distress, right? One possibility is that the total value of the debt, which is D, is greater than the present value of the future cash flows, right? In other words, the total amount of money that this company needs to pay off to its creditors is more than the present value of the projected future cash flows, right? So there's no way this company, given its present performance and unless and until we restructure the business, can generate the requisite amount of cash flow needed to repay all the debtors to the fullest amount of the debt, right? So this company is in financial distress in this situation, right? So if total debt is more than the present value of the future cash flows, this company is said to be in financial distress. Actually, it's not the company, it's the business which is in financial distress. The other possibility, scenario 2, is that the liquidation value is more than the present value. So that means that at time t0, if you are to take all the assets of the company out and sell off those assets independently in the market, the amount of money that you get is more than the present value of all its cash flows in the future, right? What does this mean? This means essentially that it's no point doing the business in the first place because you can just sell off the assets and generate more income than putting them in the business and continuing them, right? So this is called economic distress, right? So the key intuition that we need to remember is that if a company is suffering from mere financial distress, it should be continued because it doesn't make sense to liquidate that company because it makes sense to have the assets in that business because you get more than liquidation value. But if liquidation value is greater than the present value, then that company is in economic distress and you should not continue the company. You should immediately liquidate the company, right? So let's take an example. Let's assume that there's a company that has defaulted to its creditor. Now, at time t0, the liquidation value of this company is 20, okay? And the total debt is 70. If this company is continued into the future, okay, I'm assuming the discount rate is 0, okay, just for simplicity. So if you move 100 rupees across time, it remains 100 rupees. It doesn't go up or go down, okay? Just for simplicity. So if we move to the future at T1, now there are two possibilities. One is that if the company takes an interim finance of 10, the value of the company at time T1 will become 50, okay? The other possibility is that the company gets no interim finance. In that case, it will be 0, right? It will be less than the liquidation value, right? So because discount rate is 0, what is the present value of this company? Any guesses? Okay, I don't want to like put you in an embarrassing situation, so let me go ahead and answer this. So if the value is 50 and the interim finance required is 10, obviously the difference is 40, right? You make 40 out of it. And because discount rate is 0, 40 if brought back to time period T0 is still 40, right? So if present value is 40, it is more than the liquidation value, right? So what kind of distress is this? Present value is more than liquidation value. Financial distress. So the reason it's not economic distress is between liquidation value and present value. I'm talking about is between the debt and, so financial distress is between debt and your present value, right? So if the present value is 40, it's between these two values, right? So it is not good enough to pay back all the creditors because the debt is 70, 40 is not good enough. But at the same time, it is much more than the liquidation value, right? So you should not liquidate this business, yeah.
Are the interest payments being captured in the present value of cash flow or in the debt itself as a whole?
So the reason I'm not getting into that is because I'm just explaining the basics of it, but that's a good question. I mean, you know, we can complicate it for the FCF calculation, but I don't want to get into that. I'm just on the very basics of what is the financial distress and what is an economic distress, right? So but that's a good question. I will probably get into that later on. So the reason why this is financial distress and not economic distress is because it makes sense to continue the company and get 40 than liquidate the company right now and get 20. But at the same time, 40 cannot pay off 70 and therefore this company cannot pay back its creditors to the full, right? So this company is in financial distress. Now, what is the fundamental challenge in insolvency? The fundamental challenge is first to determine whether a company is suffering from the economic distress or from financial distress. And the second bigger challenge is that when we know that a company is suffering from financial distress, the incentives of the stakeholders should be such that they actually continue a financially distressed company and do not liquidate it. But on the other hand, if it's economically distressed, it is pushed into liquidation and it's not continued. Because either ways, if you get it wrong, it will lead to value destruction. In case 1, you might end up killing off a perfectly viable company. And in case 2, you may want to continue with a business that doesn't make any business sense, right? So both of these outcomes are bad. So that is the second biggest challenge in insolvency. The question then is, do we need a law to solve this problem? Or can this problem be solved by contracts, right? Now, there's this entire school of thought in bankruptcy called the contractual perspective of bankruptcy, which says that, you know, the state should not intervene, right? We can solve this problem as private parties through contracting, right? Now, okay, then the next question to ask is, what are the potential market failures in insolvency, right? Why do you want state-supplied insolvency laws to address these kind of problems? So, okay, in public economics, there's a school of thought which is kind of predominant, which says basically that markets work. However, we know that in certain situations, markets do not work, right? So, the purpose of law and regulations is to address only market failures, right? You don't need laws where markets can work, right? So, what are the two problems that cannot be solved or that may not be solved by contractual parties, right? One is the creditor coordination problem, and other is the shareholder creditor agency problem, right? These are the two fundamental problems. There are other n number of problems. They are not core to bankruptcy, but there are problems about creating a profession for IPs, etc., for insolvency professionals, etc. I'm not getting into that. These are the core problems, right? So what is the creditor coordination problem? So suppose a company defaults to one creditor, and it has multiple number of creditors, right? Now say I have taken a loan from 5 of you, and I did not pay back interest to 1 of you, right? Now, what would the other four think of it? They'll be scared, right? Because there's no guarantee that I'll pay them back, right? So the natural thing to do is to grab my assets, right? As my creditors, you would not wait for me to fail to pay you the money, right? You would immediately file under the Indian law, say, SARFAESI actions to recover your assets, right? Now, imagine I am not an economically distressed company. I'm a perfectly fine company, only that currently I'm in financial distress, right? What would be the consequence of this grab, right? You will force me into liquidation because I could have basically functioned, right? I'm a financially distressed company, not an economically distressed company. But if everyone starts grabbing my assets, then I cannot run my business. Most of the time, I'll be in DRT fighting SARFAESI litigation, right? And if DRT action is successful, my plants and machineries probably will be seized by my creditors. So I can't, carry out my business, and therefore my business will fail. And this is a bad outcome, right? Because this is a financially distressed company, not an economically distressed company, but we are going to push this kind of a company into liquidation. And that's a bad outcome. So let's take an example of this, okay? So let's say there's a company with 2 secured creditors, right? The total amount of secured debt is 70. That means that each secured creditor has a date of 35, right? The liquidation value of the company is 40, and the present value of the company is 60, okay? Is this financial or economic distress? Why? Great, brilliant. So what happens if the company defaults on one creditor? There are 4 possibilities, okay? Yeah.
So, but the present value was more than the present value was 60 and the debt was 70.
Yeah. So present value cannot suffice for all the debt holders, right? So there are 4 possibilities, right? So both the creditors can come together and agree that, look, there's only 60, right, if we run the company. Now, if we run the company, each of us can get 30-30, and then we are better off, but we won't get 35, right? But if one of them cheat, then the one person which cheats gets 35, the other gets only 5, because liquidation value is just 40, right? If both of them try to cheat and both of them try to recover, one will get 35, one will get 5, but from before, no one knows who will be able to succeed, right? Because both of them are going to DRT and trying to file a recovery case, right? So the total outcome is 40, and because probability of winning is, say, 0.5, so it's 20-20, right? So if creditor 1 and creditor 2 agrees to a debt reduction of 5 and get 30-30, and they agree and strike the deal and actually do not cheat, then they get 30-30 each, right? If one of them cheats and the other doesn't, then if creditor 1, say, agrees and creditor 2 cheats, then creditor 2 gets 35 and 1 gets 5. The vice versa, 1 gets 35, the other gets 5. And if both of them cheat, then they get 20-20 each, right? Which one do you think is the equilibrium situation here? Sorry?
Yeah, so
Why?
So prisoner dilemma, so I think they'll
Right.
end up in the last, both of them would end up cheating. So they'll
Right.
be either in 35-5 or 5.
Agreed? Right? So this is exactly what you said, prisoner's dilemma. So this is nothing but the creditor's coordination problem, because if you leave creditors to themselves, they will try to cheat, right? Now, this depends on actually the market structure of the economy that you're talking about. So for example, in UK, before 2002, the amendment to the Enterprise Act, there used to be this bunch of guys called the floating charge holders, which are essentially the secured creditors, right? They would come to an agreement and would never violate the agreement. Why? On the other hand, subsequently, a development happened in the UK debt market because of which the probability of cheating went up. Can you guess why? So, before 2002, before the reforms, the debt market was pretty concentrated. It was mainly the banks which were extending debt, right? Subsequently, a lot of hedge funds and a lot of alternative funds came into the debt market, right? Now, if you are a bank and if you are in the repeat lending game, you have friends in the banking sector, right? Because you always sit in the committee of creditors and decide. So, you develop a kind of trust. But when people who are not even regulated by the same regulator, who are, may not even be regulated for that matter, get into the same game, then this trust breaks down, right? It's like birds of the same feather flock together, right? So there's trust between the banks, but a bank cannot trust a hedge fund can't trust a bank, right? So because of this, in certain economies where you have concentrated banking market or concentrated debt market, you may not see this behavior. But in economies where you have a bond market, you have a bank lending market, you have hedge funds lending, etc., there you might see this possibility, right? So I mean, this is a very simple model, but I just wanted to clarify this. This really depends on the market structure. This is also called the common pool problem or the collective action problem. The essential problem here is that there is no sole owner of the property, right? Because of which the entire problem of coordination comes in, and then the problem of cheating can crop up. So what are the potential solutions to this problem? One is you can have a collective insolvency procedure, right? So this is a procedure that came into UK in 2002 through the Enterprise Act called the administration process that came in. So basically an insolvency practitioner as an administrator has a duty under law to maximize returns in the interest of all the creditors, right? So it's not only the people who are in the business of banking who can call the shots, right? That was the idea. So the idea is that everyone has to be within the same resolution process to prevent this possibility of the coordination game not working out. Okay, now since you are all very connected to the Indian developments of late, under the Indian law, once a default happens, any creditor can trigger the bankruptcy code, right? And then the entire corporate insolvency process starts where all the creditors are involved. The financial creditors who are in the game or in the business of lending, they are called the financial creditors. They are in the COC, and the other creditors are the operational creditors who are not in the COC, right? Now, there was some litigation that happened where an operational creditor, being any creditor, filed a CIRP process and started the entire, the resolution process, but then entered into a bilateral settlement with the corporate debtor, right, with the company. Do you think this should be allowed? Because is this a breach of the collective insolvency procedure? Are you guys aware of this? There was a Supreme Court judgment by Nariman on this, and now there are regulations allowing settlement. So do you think bilateral settlement should be allowed?
Amendment also allows for taking back an insolvency once triggered.
Right. So my question is not what the law says. My question is that a good law or a bad law?
I think it should be okay because it just means that company has a capacity to actually pay off the debt. It could signal that.
Okay.
So I think there's a probability that.
That's a good answer. So anyone else with a different view?
It keeps out the unsecured creditors.
Sorry?
The bilateral settlement is only for that one creditor, for the other.
Yeah, but that was the guy who only suffered, say, who faced the default, right? So, and he now wants to withdraw the case.
Realistically, there's always
Yeah, but say, say, for example, if someone else has defaulted, if there is another default, some other person can again come and file the case, right? So you're not stopping another CRP proceeding from being filed. What you are doing is you are essentially withdrawing the first one, right? Should withdrawal of a CRP proceeding be allowed because of bilateral settlement? That's the question.
Yes, that should be allowed because then going back to what you said earlier, because if one creditor goes against the company, the other also comes and they try to rip apart the company. So this then stops that because you can just settle that creditor there, and then if, as you said, if other creditors have problems, they can come and they can also secure their debts and wherever they want.
Yeah, but there's also a possibility that a company which is, say, cash rich, right, but is balance sheet insolvent, has defaulted for the first time, and you are just delaying the entire resolution process. So it defaulted for the first time, so it has got enough cash to pay off for some time, but its total liabilities are more than its total assets, so it's balance sheet insolvent, right? So
it depends when does the liability actually?
I agree, but there's a possibility that it has failed to pay up one operational creditor because it wants to pay off some other bigger creditors. But in the process, now if you allow the settlement to happen, you are essentially delaying the entire resolution process. And as we know, if you delay the insolvency process, you are essentially losing value because the earlier you go into restructuring, the better it is, right? So anyone with a different view, he already has a great argument in favor of the withdrawal. So
I believe that if you started the insolvency process and your COC has been appointed and you have an RP and the entire process has started, it's more difficult to restart the process for a different creditor. And so therefore a bilateral settlement is, to keep it in simple terms, selfish. It doesn't keep the entire process and compromises the entire
okay,
insolvency process.
okay. So let's add another. Yeah, please.
So if you're having an insolvency process initiated, that is affecting the rights of all your creditors. Okay? Merely because the person who instituted the cause of action, so merely because somebody who had a cause of action is now saying I don't have a cause of action, would the rights of all the other creditors also be affected? Because, I mean, I'm just going back to an earlier point in your law, where the threat of default remains,
Yeah.
right, for
Yeah.
the other creditors.
Yeah.
And now we are in a situation where an independent professional, financially educated, is looking into the the matters of the company,
Yeah.
and taking a good hard look at whether or not that threat of default is going to exist in the future. Even for bilateral settlements, I don't see a reason why we should withdraw. We should be able to withdraw an insolvency proceeding.
Yeah. So I mean, so this was one of the heated, recommendations of the Insolvency Law Committee. So there are arguments for both sides, right? One argument also against that could be that this is a new law, right? You need some time for the market players' behavior to change, right? So maybe if you let this law be the way it was without the withdrawal, they would just change their behavior, right? So they would contract around what is, how they pay the operational creditors, etc., right? So this is a problem with coming up with amendments to a law right after it has been brought in without enough evidence how it is changing the behavior of the parties to the game, right? For example, we don't know how the market structure in India affects the incentive of different parties. I mean, it's not enough time. 6 months or 1 year is not enough time, right? You need to collect enough evidence to make the reform. But what is happening in India is that we are rushing through a lot of reforms. So if you see the ILC's report, they have not done any data analysis or anything like that to establish why withdrawal is not is beneficial or why withdrawal is a bad thing, right? As we discussed, there are arguments to both sides, right? So, I mean, I don't want to give some kind of decisive answer because there is none, but as of now, as you said correctly, withdrawal is allowed by 90% of the COC agreeing to the withdrawal. The second issue that I wanted to touch upon is another solution to the creditor coordination problem is the moratorium against individual recovery actions. As you know, under the Insolvency Code, once the CIRT starts, no legal proceeding can be brought for recovery of assets against the corporate debtor, right? Now, question one. Does it prevent the SARFACI action, recovery action against personal guarantor?
It doesn't, I think, because they say there's separate assets, the guarantor as well as of the
Right.
insolvent company, their assets are different.
Right. So yeah, so there was, obviously there were cases where the promoters basically when they are giving out a loan, give a personal guarantee, and the question was that if there is a moratorium on the company's assets, should it extend to the promoters also? I mean, should it protect the promoters' assets also? And as he said, it's a, sorry, what's your name? Amul.
Approved.
Apurv. Okay, so as Apurv said, the case law now suggests that no, the moratorium cannot extend to anything beyond the company's property, right? Because it makes sense, because the entire coordination dilemma is regarding the company's assets. It has nothing to do with the promoter's asset, right? So from an economic perspective, it makes sense. Question 2. What about a company that has got a favorable arbitration award in its favor and a section 34 petition is filed against it, right, to set aside the arbitration award? Is that included in, can the section 35 proceeding continue, or is that barred by moratorium? So the award has been in favor of the corporate debtor, right? And now a section 34 has been brought in to set aside that award. In that sense, it's a contingent claim on the company, right? Because if the section 34 is successful, then the company doesn't get back this amount of money, right? So should this proceeding be stopped under the moratorium under the insolvency code? From the economic perspective, do you think this is justified?
Technically, from the economic perspective, yes, it could be.
Why?
But I'll just add to it.
Yeah.
But in situations where you have a 34 pending and a moratorium period is also pending and the creditor has already a creditor has an award. In situations like these, so under the English conditions, you have the administrator, right, which technically stops any arbitration proceeding, if I'm not correct, and goes ahead with the moratorium the insolvency proceeding. Under any other law, basically there is not enough clarity to this extent. There is always a fight between 34 versus the creditors committee system which is working on right now. That gets further complicated when the award is set aside.
So I agree.
It's majorly, I'm really sorry, it's majorly on A, discretion of 34 court. B, it is also dependent to a greater extent on what was the law governing the arbitration agreement and what is the law governing or what is the incorporation of wherever the moratorium or the insolvency proceedings or that thing is going on. So it's basically more or less about a conflict of law analysis. On the legal front, of course, economically, somebody who's paid some money should be realized, and given the fact that there is an arbitration award to it.
So okay, so I appreciate the point on the legal complexity in enforcing it. I understand the complications, you would know the arbitration side better on this, but my question is, from the creditor coordination problem perspective, should this proceeding be stopped? Mind you, this is not an arbitration proceeding. This is not an execution of the award proceeding. This is a setting aside proceeding, right?
Yes.
So should it be stayed or should it continue purely from the creditor's coordination game?
So if the award is against the creditor, it means
Yes.
you said the award is in favor of
So
the
the
creditor.
right,
Then the creditor does not have any. So if you treat that award as a decree,
yeah.
then the creditor does not have any tech which is owned by the company directly. Like I don't know what that was.
Right.
So in that manner, it is no more a creditor coordination problem because
Right.
the creditors who have a debt which the company actually owes the debt,
Right.
but still there.
Right.
This is just.
So, yeah, you have.
Yeah, I'm not very sure about this, but I mean, from what I understand, if there's an award in favor of a particular creditor, right? That's just
In favor of the debtor, corporate debtor, of the company itself. So they would get money, right? That would expand the company's assets, right? Which is exactly what you're trying to protect, right? This judgment or this award holder now wants to prevent this assets of the company from swelling in favor of all the other creditors, right? So that person brings in a section 34 to set aside that award. The question is this proceeding, if it is allowed to run, does it go against the basic philosophy of insolvency, which is to maximize the company's assets?
it does in that sense because I mean, it would be in the favor of all creditors to collectively have a bigger pool of sort of the
Right.
value of the company
Right.
to unpick at a later stage or to get back their own.
Right, that's a good answer.
I
Yes.
think it depends on at what stage the award was made. I mean, it could be way before the company hit the insolvency, like approach the insolvency. So it was not this particular award or this situation of the company which led to this award, like in the favor of debt.
Okay.
So that creditor against whom the award is, he might be because of some previous, a failure of the company to pay. So
Okay,
that's
there can
the-
be
yeah.
other possibilities. So, okay, so all of the arguments that you've made, these are all potential arguments. What I wanted to point out here is that there's this entire gray area as far as contingent claims are concerned, right? And this is a pretty complicated area in insolvency law in general. How do you treat contingent claims, right? So under the bankruptcy law in India, it's still evolving. And in accounting standards, etc., you might have to treat them differently depending on which accounting standard you're following, right?
Sorry,
But,
I'm
yeah.
really sorry.
No, no, please.
Would this then, in case, I would say, for instance, the moratorium is still on, this will be a contingent asset which is outside the liquidators, outside the estate.
So this is a contingent asset for the company because now this is under litigation or arbitration. So we don't know the outcome, right? So if you are treating it as a property, then your accounting standards may require you to do take a provisioning requirement, in the sense like you can take a percentage of that when you're calculating the company's assets because it's a contingent claim. So there are a lot of possibilities how you can treat it as an asset. As a contingent claim, you can't treat the entire thing because you don't know what is the probability of winning this case, right? Now, interestingly, the Delhi High Court, this was a question before the Delhi High Court in one of the cases, and the Delhi High Court said that this case does not fall within the moratorium, right? So currently under the law as it stands, as said by the Delhi High Court, this does not fall within the moratorium, but as I said, it's a contingent claim, and this is a pretty complicated area in general in insolvency law across jurisdictions. But after the Delhi High Court, no one I think challenged this decision in the Supreme Court. So probably someone in future will challenge the Supreme Court and things will get clearer. Also, IBI, the bankruptcy regulator, is coming up with a lot of new regulations, but I think this is still a pretty contested area. The third way of solving this problem is by something called avoidance of preferential transactions, right? Now, this is something that I wanted to discuss in a bit detail because this is something not new under the Insolvency Code. This is there in Companies Act also, but this is a very, very interesting feature that happens in insolvency. So this is a case that NCLT decided last month, right? This NCLT had Allahabad. GR Agro versus Swadesh Oil, in case you guys are interested. So what happened was that SBI gave a loan to a company, right, which is going to get insolvent, but was perfectly fine at the time when the loan was extended. The promoter of company C stood as provided a personal bank guarantee, right? Now, at time T-1, the company is still not under the IBC CRP proceeding, right? It's still not there. At time T-1, the company paid out 50 crores to SBI as a part of the debt repayment, right? Then the company hits insolvency. The insolvency commencement date is after that, T0, the red line, right? And then the resolution plan is approved. Now, interestingly, in this case, SBI had 88% of the claim. So in the committee of creditors, SBI had 88% vote. So as you know, previously it was 75%, now it's 66%. So essentially SBI can call the shots on the committee of creditors, right? In the final resolution plan as approved by the committee of creditors, which is essentially SBI, there was no payment to SBI. There was debt to the income tax department and to other operational creditors were written off. Not all of the operational creditors, but some of them were written off. So basically they would get zero, they would get nothing. And the property and the company's business was sold to a related party of the promoter, right? Question 1, why do you think the company at time T-1 paid 50 crores to SBI? Why? What sense does it make? Look at the image. What is unique about the loan that was given?
Personally guaranteed.
Yes. So what is the promoter doing by giving the loan back, by repaying the debt to SBI?
So discharging the guarantee obligation of the
Exactly. So the promoter knows that this company is going to get insolvent, right? But I don't want SBI to come and take my dwelling house, right? So what do? You give a preference to one of your big financial creditors. Look, there are other 4 financial creditors, right? You don't pay any of them because you have not given any kind of personal guarantee to them, right? You just pay off SBI 50 crores because you know now you're going to insolvency. If you go into insolvency without paying SBI, your personal guarantee will get triggered, right? So they are paying, the promoter is paying off, through the company is paying off SBI, taking the company into liquidation. SBI being the major creditor decides to write off the debt of everyone else and pay some other guys and make a resolution plan. So when the case came up before the NCLT, the plan was approved by more than 75% of the creditors, right? So the argument that the counsel for the COC, the Committee of Creditors took, was that NCLT does not have any power to review this resolution plan because it was voted by the majority in the COC, right? What do you think the NCLT should do in this case?
They should not get into it because that's a specific jurisdiction of the COC. To look into the entire
Right.
the proposals or whatever the manner in which they have devised the resolution plan
Right.
is beyond the jurisdiction of the NCLT person.
Brilliant. That's a great argument because that is exactly what the law says, right? What is the counter argument?
I think if you take an analogy from like working with a company, it's almost like oppression, like in the COC itself. Because the other minority creditors also, their rights are being trampled upon by paying off the SPL, so they won't be getting as much as they could have.
Oh, yes, sir. Okay. Sorry. So you are saying that anyone else could have also done this?
Yeah, and also like they could have bought more, like the assets of the company would have been more if they wouldn't have paid SPL fees.
Exactly. Right. So then, what do you think the NCLT should do? It should basically say that no, I don't care. I will stop this plan from getting approved.
So they should have a requirement of having that this equitable standard sort of.
Okay. So what do you mean by equitable standard? Let's just understand. So what do you mean by the equitable standard here? Can you flesh out what is the question of equity here? What is wrong with this? You understand this is morally wrong, right? What is it that is wrong here? What is wrong that is happening here? You have an answer?
Nothing is right now, but from what I can see is that he's kind of using the company's money to pay back.
Yes, exactly.
And that's morally wrong in the LCLT, even though it does not have jurisdiction, but it has a moral responsibility of still looking at these kind of matters, subject matters, and therefore maybe a review or something.
The problem in writing a law is that you cannot write that if it goes against your moral standard, you should pass a judgment. That's too vague, right? If you were to write the law, how would you write it without using moral standard? In insolvency, in this case.
If it is found out that one creditor has been treated preferentially over the other,
Yes.
then the NCLT can retrospectively go back and
When?
if it is found out that it was done for the personal benefit of the promoter or like in this case.
Yeah, but when?
When
At what point of time should a promoter not give preference?
Pre-insolvency commencement.
1 year.
That is like eternity.
1 year.
Sorry? Yeah.
A year before insolvency.
Yes. So a year before insolvency for
when
everyone.
we get to know that insolvency proceeding is going to start. It may happen like before.
Okay, so right. So the assumption is that no one really plans through 1 year. It's too far because that means that you're so cash rich that you keep on paying. Usually companies do not keep that much of cash with it themselves, right? So 1 year for everyone and 2 years for related parties, right? Because there the possibility of planning can come in, right? So this is a provision that was that is there under Companies Act, but not as fleshed out, and especially because this is more of an insolvency thing. So the way look, we all understand this is morally wrong, right? And this is exactly why judgments from I think the Elizabeth statute in 1500s has been telling that this is wrong, right? It's only in, I think 1986 that this was formally called avoidance of preferential transaction, right? Now, the law does not say that you are prohibited from doing this transaction, right? What the law says that if you have entered into this transaction, the state in the form of the adjudicating authority or the judges reserve the right to avoid this transaction. So you are free to enter into the transaction, right? So like wagering contracts, right? You are free to enter into a wagering contract. Only don't come to the state and ask for an enforcement, right? So it's like that. So the law doesn't say that this transaction is prohibited. But if you enter into this transaction, you run the risk that this will be unwound at some point of time in the future, right? Now this is a core principle in insolvency law, because this will exactly happen. Every promoter, everyone in control will try to give the money back to one of the biggest lenders because they have other businesses, right? They have other businesses where they are taking loan from this guy. So they have some creditors whom they value for subsequent ventures. And this is a unique problem that happens in insolvency, and we will get into why. Yeah.
So there's one more problem. So when SBI took the personal guarantee, SBI took the personal guarantee with the view that my loan will be secured when the time comes.
Agreed.
And before that, given that this sword is hanging on the promoter's head,
Yeah.
he'll pay off my debt before the
Yeah.
insolvency ruling, so
Yeah.
that he does not get personally involved in this.
Right.
So there was a bit of consideration we have been given by the SBA for this. Maybe the interest charge was less or something. There can be a consideration. So you're actually not upholding that contract.
So I agree that party autonomy. Sorry.
Is the SBI's duty to look at the matter in such a way?
So that's why the law is not saying that you can enter into any of these contracts, right? But party autonomy is valid. The state accepts that party autonomy is the principle. The only exceptions are created in the law, right? One exception is in insolvency, and I'll explain. And most so, this is not SBI's fault. The fault is the promoters, right? Because even if they have gone into insolvency, SBI would have got this money back from the promoter, right? SBI would have got back its money. So SBI is indifferent. It's the promoter who is paying off money through the company instead of taking the responsibility on its own, knowing fully well as an insider in the company that this company is going into insolvency, right? So this is essentially the problem is with the promoter. The fault is with the promoter, not with SBI, right? So I hope I have answered that question. Okay, now let's go to the next problem that crops up, right? This is called the shareholder creditor agency problem, right? Think of equity shareholders or equity shares as a call option on the firm's assets, right? So essentially, you have a right to buy and your counterparty has an obligation to sell the firm to you, right? So the shareholders have entered into a contract with the debt holders that we have a right to buy off this company and you have an obligation to sell this company the moment the strike price is the same as the debt value, right? So look at the graph, okay? So this red line is the value of the call option. When the firm asset value increases, it is still 0. It keeps on going up to 100. Okay, this line, just ignore this line. Okay, this is the point, 100, right? 100 is the required debt payment. So D is equal to 100, right? So till that time, equity shareholders' value is 0. The value of equity is 0. After that, once you have paid off your debt holders, then your equity holders' value keeps on going up in proportion with the value of the firm, right? It's 45-degree angle, right? So essentially, equity holders have every incentive to try and push the company towards this side of the axis, right? So this incentivizes risk-taking by shareholders. On the other hand, the debt holders are not taking any risk, right? I mean, they're not taking the same amount of risk that because their upside is capped, right? So the shareholders in the vicinity of insolvency, when they know that the company is going to go to the debt holders or the assets will be given to the debt holders, what will they do? What do you think, if you are a shareholder and you know that the company is moving towards insolvency, right? What will you do to make the call option that you had bought at the time when you bought the share worth something more than 0? What will you do? That's one way, provided the debtors agree, but you can't unilaterally delay, right? So what will you do? See, okay, now when I talk about the shareholders, I'm assuming that the shareholders are also the managers of the company, okay? So as managers of the company, what you will do is you will engage in the riskiest activities possible, right? And I'll come to this later on. So when you see the company is going into insolvency and the value of your call option is going down, I mean it's 0, you would try to increase the value of that call option, which is your equity share, right? And you will do that by taking the riskiest projects to increase your free cash flows, right? So that your present value increases, right? So this is something that we will remember because it's relevant later on. There's another very funny thing about a company, right? A company is not, the shareholders are not just holding call options. The shareholders also enjoy something called the limited liability, right? What is limited liability? Essentially, the creditors of the company do not have an action against the shareholders, and the creditors of the shareholders do not have an action against the company for the, right? So that's called entity shielding. We are interested in limited liability, right? So that's also a layer over the call option aspect of the equity shares. What would happen right before insolvency, right? When we mix these two things together, right? again, my assumption is that the incentives of the shareholders and the managers are highly correlated. Okay, essentially, whatever the shareholders say, the managers will do. Once we challenge this assumption, this model kind of breaks down, right? So, when the company is going towards insolvency, the shareholders, being the managers, know that it's going towards insolvency, right? So, they would want to take high risk, high gain strategy because that's the only way they can increase the call option value beyond zero, right? So, what will essentially happen is that they will substitute the assets of the company which are with riskier assets, right? So, they would want to expand or increase the free cash flow out of the project, right? So, they would try to take riskier projects, right? And that is something you want to prevent. Because creditors signed up to you doing X project. Now, if you are taking a Y project, that's a problem. I never gave you credit for that business, right? So, what usually happens before insolvency, if there is no state supplied insolvency law, is that the shareholders, being the managers, have a huge incentive to engage in all kinds of risky activities, right? This problem is called the asset substitution problem because you are substituting the less risky assets with the high risky assets, right? The second problem is called the asset dilution problem. This is essentially what we hear in India all the time, siphoning off, right? But in more formal terms, it's called transaction at an undervalue or transfer at an undervalue. So shareholders, through the managers, control the company, right? They can, one, sell off the assets of the company to their related parties at a very cheap price, right? So they gain because the related parties gain, right? The other is they could sell off those assets at a lesser price to the market players, anyone, not related parties, but anyone, get whatever money they get and push it to the shareholders in the form of dividends, right? That's also siphoning. The third is they just drive a truck at the middle of the night and steal assets, right? Which is like just stealing assets, which is also siphoning, right? So there are three possibilities, and this is happening again because of the shareholder creditor agency problem, right? The third problem is debt dilution. What could happen is that the shareholders, when they know that this company is getting into insolvency, may take credit at a much higher interest rate, right? Because no one's going to give you credit when you are going into insolvency. So they may take credit at a much higher interest rate and create more encumbrances on the company. Now, you can contractually solve this problem if this guy's put a contractual clause saying that you cannot put more encumbrances or whatever. So this problem can be solved contractually, right? But essentially, these are the three problems. However, there are legal provisions to address these problems, okay? So the first is transaction avoidance. We have already seen what is a transaction avoidance, right? For the preferential transactions. Now, we have a transaction avoidance for undervalue transactions and the extortionate credit transactions, right? The last example that we took. The second way of solving this problem is by imposing personal liability on managers. So there's a provision on wrongful trading or fraudulent trading, right? So when you as a manager of the company know that the company is headed towards insolvency or is likely to go into insolvency and you start engaging in high-risk businesses, you are culpable of wrongful or fraudulent trading, right? The third one is director disqualification, right? You disqualify directors. Now, we have got these provisions in place. The director disqualification provisions are in the Companies Act, and I'm not sure if that really is very much in tune with the insolvency law, right? Because, I'm not sure about that. So I think what currently is happening is that most of the judgments you read, they go and pierce the corporate veil because they do not understand these provisions as of now. What are the implications of these provisions? So if you read the NCLT judgment that I mentioned here, they are writing all kinds of things. This is avoidance transaction, this is preference transaction, undervalue transaction, everything. But they're not fully aware of the differences between each of these provisions. And the Supreme Court is going and piercing corporate veils in every judgment, right? And that is a problem. See, the reason why these things have developed is that you don't want to pierce the corporate veil. You want to unwind the transaction, but you don't want to pierce the corporate veil because as we know, limited liability is a crux of corporate law, right? You don't want to dilute that principle. Unfortunately, in India, although we have got these provisions in place, I think there's very little awareness in the legal community about the use of these provisions. And that's why you see everyone arguing that let's pierce the corporate veil, right? So, with this, I'm at the end. It's a short presentation. I if you want, I can discuss some of the other interesting policy debates that are happening in insolvency, but depends on, because it's 4 o'clock, I don't want to take too much of your time, you have plans for tomorrow, etc. So if you are interested, we can discuss some of this. These are interesting stuff that's happening in the insolvency space as of now. But if you have any questions, any comments, more than happy to entertain. Great, thank you. Thanks a lot. Happy Independence Day.